Welcome to This Lawyer's Life, a podcast of the New York City Bar Association. Today we meet Greg Diskant, a senior litigator at Patterson Belknap and former chair of the firm. In this special episode, Greg is interviewed by City Bar President Mohammed Faridi, a Patterson colleague. They discuss key moments from Greg's illustrious career, including his clerkship with Justice Thurgood Marshall and his experiences as an assistant U.S. attorney.
The other thing that's fascinating to me is I learned long ago that you can beat any expert.
The conversation delves into leadership at the highest firm levels.
You have to be respected and trusted by your colleagues. You have to be fair to everyone. And I came to think of this incorrectly, but emotionally, as my firm.
Greg has a high-profile record in public interest litigation as well as patent litigation. He's got notes on both.
You're going to win. You're going to win on appeal, Mohammed. That is the lesson I'm about to tell you.
Opinions expressed are those of the speakers and not necessarily of the City Bar. Here's your host, Gregory Binstock.
Welcome to This Lawyer's Life, a professional development podcast where we talk with lawyers about seizing opportunities, learning lessons the hard way, and about what makes them tick. I'm Gregory Binstock, Director of Professional Development here at the New York City Bar Association, and today I have the pleasure to chat with Gregory Diskant. Greg Diskant, you are a senior litigator at Patterson Belknap, where you served as chair from 1997 until 2007. You have secured billions of dollars in judgments for your clients, and prior to joining Patterson, you served as Assistant United States Attorney and as Chief Appellate Attorney for the Southern District of New York. You also served as a law clerk to the Honorable Thurgood Marshall at the Supreme Court of the United States. And now you're here with us. You're of counsel at Patterson Belknap, which makes you a longtime colleague of City Bar President Mohammed Faridi, who is joining us here today to ask you some stories and lessons from your career. Welcome to Gregory and welcome to Mohammed. We are so glad to have you join us. Thank you both for being here.
Happy to be here.
Thanks for participating in this, Greg. So why don't we begin with the early phases of your career? You obviously clerked for Justice Marshall, and before clerking for Justice Marshall, you clerked for the D.C. Court of Appeals for Judge Skelly Wright. Can you share some vignettes from your experience with these two great judges that summarize or encapsulate your experience while clerking?
Sure. These are both heroes of mine, and I was extremely fortunate early in my career to get a chance to spend a year with each and just bask in the glow of their intellect and heroism. Skelly Wright is probably not so well known anymore, but he was one of the brave district court judges when he was on the district court in Louisiana who helped desegregate the South. And you may all remember or know the very touching portrait by Norman Rockwell that shows a little black girl in New Orleans in a white dress with her hair in pigtails, surrounded by beefy U.S. Marshals, walking to school, and the wall behind her has tomatoes on it and racial epithets. It just captures the anger and hostility of that time period. That was Skelly. Skelly's decisions in 1959, 60, 61 caused the desegregation of those schools. And he was an old line Southerner. And yet he told a story, one day looking out the window of his chambers, and it was Christmas Eve. And there's a school for the blind across the street. And he looked out the window and he saw blind people, black and white, coming to a Christmas party. And the black people walked in through the colored entrance, and the white people walked in through the white entrance. He thought, oh my goodness, these people can't even see each other. And yet they're separated by color. And it made a profound impact on him. This led to crosses burned on his front yard and eventually his elevation by John Kennedy to the D.C. Court of Appeals after all the Southern senators blocked his elevation to the Fifth Circuit. So I had a thrilling time with Skelly, just hearing these stories and watching him in action. And then I had the equal or even greater honor of having the chance to work with Thurgood Marshall, who actually knew Skelly from forgive me for calling him Skelly. It's been a long time. I called him Judge throughout his life, but I feel we're sort of friends now. But anyway, and I feel the same about Marshall. But so Thurgood litigated the New Orleans case in front of Skelly, and they became pals then. And Thurgood, the court was turning then. This was in 75, 76, and it was moving in a conservative direction, but it was a time when conservative judges would support liberal decisions. There was Harry Blackman on the court, and John Paul Stevens was sworn in while I was a law clerk, Sandra Day O'Connor. It was kind of a different world, but but the tide was turning, and Thurgood increasingly felt outvoted on the court. But he was a man of great good humor, great experience. Every day around 4 o'clock, he would come into the chambers and plop down in a giant easy chair. And it had to be giant because he was a large man, and tell stories. And clerks around the building would know it was story time in Marshall's chambers and would come and sit on the floor, and he would tell amazing stories from his career. He had an ability, probably necessary to preserve his sanity, of taking horrible stories and making them funny. And I'll tell one simple anecdote. When he was a brand new judge on the Second Circuit, he was supposed to go up to the chief judge's chambers for a photo opportunity. And so he goes up, and he's a newcomer on the court, and he walks into the chief judge's chambers, and the secretary looks at him and says, "Oh, I'm glad you're here. The busted electrical outlet is over there," pointing. And of course, he was misidentified, as black men so often are when they achieve positions of power. And so did this insult him? Did this anger him? He thought it was hilarious. He came back to chambers and said, "That woman has to be an idiot to think that a black man could get into the electricians union in New York City." So it was funny, and it was also making a point about the persistence of segregation in New York City at that time in the early 60s. Anyway, there are tons of Marshall stories and Skelly Wright stories, but I was privileged to see them both up close.
Did you have any conversations with him about his father's experience in dealing with bigotry and racism, and how that informed his view of the world, along with his own experience?
He was part of the background of the stories Thurgood told. My recollection, which may be incorrect, is that he was a porter on the railroad, and Thurgood, rode free on the railroad for some time as a result of that. But his father was very interested in education, as was Thurgood as he matured. And so his two sons, Thurgood became a lawyer, and Thurgood's brother became a medical doctor. They were both professional black men at a time when that was a rarity, and they were both high-achieving black men. So Thurgood came out of that with a profound belief in education, which led to all the litigation leading up the board against Brown, and a respect for professional achievement.
You talked about justices who were conservative justices in the 70s who sometimes supported liberal justices' decisions, Justice Blackman and Stevens, who ultimately, I think, had some transformation during the time of court. We don't see that anymore, and we're seeing less and less of that. What do you think is happening with the court, where the liberal justices and the conservative justices are so misaligned with each other on some of the more basic issues, or issues that you and I might perceive to be non-controversial and basic?
Well, what's happened is presidents, and I think this began with Republican presidents, but is probably utilized by Democratic presidents as well. There was a time when judges, I was imbued with this when I was in law school. Justices are picked on the quality of their intellect and their reasoning, and senators approve justices based on that and not based on politics. And the prevailing view when I was in law school was that the president gets to pick who he wants to put on the court. That's just a given. and the only issues are quality. And what has happened is there, there are a number of justices who were appointed by conservative presidents and moved left. And the examples, Blackmun, Stevens, as you mentioned, Stevens was appointed by Gerald Ford. And the year I was clerking, he voted to uphold the death penalty. And years later said that was his major mistake on the court. And so Sandra Day O'Connor was a swing justice. Anthony Kennedy was a swing justice. And basically, beginning with Republicans, but I think followed by Democrats, they began looking for judges with track records as judges. So the idea of appointing someone who didn't have that track record disappeared. Souter was another conservative appointee who became relatively liberal while on the bench. But looking not merely for records as judges, but as strongly, deeply imbued conservative philosophy. There was quite an uproar when George W. Bush attempted to appoint his counsel, Harriet Miers, to the Supreme Court, and the conservative right was violently upset that she might turn out to be another Souter. And he withdrew that application, that nomination, and wound up nominating Sam Alito instead, because he could deliver the goods, and he certainly has. Now, to be fair, Democratic presidents have done something of the same. Sotomayor had a long track record, but also people like Elena Kagan had never been a judge before. And her background was really just as a practicing lawyer who was very smart. And to that extent, Obama took a risk if you think guaranteeing results is the job of the president. But if you think nominating quality people is, then it was a good choice. So we're in a different era today.
So, Greg, you've focused most of your career on trial work in government first as an assistant U.S. attorney and then in private practice at Patterson Belknap. What do you find to be the most interesting thing about trial work? And tell us also, what's the most challenging thing about trial work? Are there parts of trial work that you don't particularly like?
Oh, I love trial. Let's start with that. I have been blessed in my career with the opportunity to try lots of cases, often 2 or 3 times a year. And that is something, as the trial and the jury trial has more or less disappeared, I really relish those opportunities. And trying cases is exciting. They're live contests of intellect and skill. I love in particular jury trials because when you try a bench trial, everyone knows what's going on. But when you're trying a jury trial, the jurors don't. And so you're really alert. You're worrying about giving a look to a colleague, what they think about how you stand up, what they think about what you're wearing. And so it's a very different experience, and it just requires all of your senses. I like the facts more than the law. I like the law just fine. I mean, I'm a lawyer. I like law. But to me, what makes jury trial work so interesting, and I think the secret of success in jury trial work, are the facts. And the facts need to be learned. I tried a lot of cases that are very technical and complex, many in the pharmaceutical industry, requiring learning how drugs work, how medical devices work, complicated technical facts that need to be mastered. But the thrill of trials is, first, you get to work with highly qualified experts to learn the science of whatever it is you're presenting to the court, and master it. And I would joke my knowledge of science might be an inch thick, but when it comes to the case I'm on, it's a mile deep, and it's kind of thrilling. I had a good friend who was a renowned medical doctor, and we would frequently chat about my cases. And I would realize that when we were talking about the science relating to an actual case I was involved in, I knew more than he did. And when I would tell him this, and he said, and then we'd have an interesting high level conversation. And then he would say something natural like, oh, that reminds me of this. I wouldn't know what he was talking about. So it's fun. It's quite an exhilarating experience.
Are you intimidated sometimes by the details, by complexity, or do you go into these cases with an attitude that, hey, the more complex it is, more intellectually stimulating it will be to master the facts?
Well, I'm not sure I go into it eager to be in the most complicated cases, but I have been in very complicated cases, and I have enjoyed mastering the facts. And I've some of my closest friends. I'm going to have a call tomorrow with an English MD who was a witness of mine for years, and we just became good friends. And so learning the facts is exciting. And the other thing that's fascinating to me is I learned long ago that you can beat any expert. And that's one of the joys of cross-examination. You can beat any expert because of two things. One is every single science has assumptions. And I guarantee you there is no science so well established that there isn't some assumption buried in it. And you can dig at the assumption and challenge the expert on the validity of the assumption. And you're always going to score at least a few points. And the other thing, and probably the more important thing, is as a trial lawyer, I care about the issue in the case more than the expert does. The expert is showing up, he's being paid, he's studied this, that, or the other thing, but he doesn't live it every waking hour of every day or perhaps years. And so I think with good cross-examination skills, you can I've examined Nobel laureates and did just fine. There's one case in which the lawyer on the other side had a Nobel laureate who had been knighted, and he wanted to call him Sir John in the courtroom. Sir John, let me direct it. And I still remember Judge Connor in the Southern District of New York peering down and saying, we fought a revolution over this. He's Dr. Vane in my courtroom. Anyway.
So
The New York City Bar Association is a dynamic community of over 23,000 legal practitioners. Members shape the future of the legal profession, serve the public, and gain an edge in their careers. To learn more about becoming a member of the City Bar or to join today, visit nycbar.org/join. Save 20% on semi-annual dues when you join. Call Customer Relations at 212-382-6663 and use code POD24.
So, Greg, you were the counsel of record in Ruco versus Common Cause, which was this very high-profile Supreme Court case on a highly controversial subject, election gerrymandering. How did you get involved with Common Cause, and how did you approach litigating this case?
Oh, well, I've always been interested in democracy issues. Common Cause was created when I was in law school or college, 1970. John Gardner, who was the former secretary of HEW, then called Health, Education, and Welfare, created it. His line was, everyone has a lobby except the people. This is the people's lobby. And so he created it. I've been a supporter of it forever. I actually became involved actively when my friend Emmett, who I mentioned earlier, wrote a brilliant law review article demonstrating filibuster was unconstitutional. Another issue that's dear to the heart of Common Cause. And he brought a lawsuit challenging the filibuster as unconstitutional. And I volunteered to do an amicus brief in that case and did. And then I joined the board, and now I'm the head of the litigation committee of the board. We brought suits against the president's efforts to exclude illegal immigrants from the census, against Texas's efforts to count only citizens in their redistricting. These are issues dear to our hearts. And, if we don't just volunteer to do it, which since I am blessed with a law firm strongly believes in pro bono work, we'd find someone else, but these are great cases. We loved litigating them. Rucho is a case of critical importance to our elections, and its loss was a terrible disappointment to me. Partisan gerrymandering goes back to the origins of the Republic. Patrick Henry gerrymandered the first congressional districts in Virginia in an attempt to defeat James Madison. And in modern times, it's become a high science in which there's so much data available and voters' preferences are so predictable that with the push of a button in 5 minutes, you can turn a state red or blue. And that isn't right. I think one of the easiest ideas that is widely accepted across the political spectrum is that voters should choose their representatives and representatives shouldn't choose their voters. But that's what happens in partisan gerrymandering. For years, I've been on the board, the National Governing Board of Common Cause, which is a major democracy organization. And gerrymandering has been one of our hot button issues. And in the late teens, I guess, it really came to the fore. And with my colleague and board member, Emmett Bondurant, who's a legend in voting rights, we had our eyes out for a good case. And we got involved in one in Wisconsin, and that didn't go anywhere. But then North Carolina came along, and it was the perfect vehicle for this challenge. It was perfect because in most gerrymanders, the legislators in power lie about what they're doing. They say, oh, no, we drew this line because we wanted to follow the river, or we drew this line because there's a pool of like-minded citizens here who have an interest in water rights, or some baloney, basically. What was remarkable about North Carolina was the legislators said out loud what they were doing. It's a partisan gerrymander, they proudly brag. And North Carolina is basically a purple state. It has Democratic governor and Republican gerrymandered legislature right now. And the legislature bragged that they had 13 congressional seats. They produced 10 Republican seats out of their gerrymander. And they bragged that they would have produced 11 if they only could. So this was the limits of science. There was 10 Republican seats, when in fairness, it should be 6 or 7 Republican and 6 or 7 Democrat. So we filed suit right away. And because we've been following the issue closely, we aimed our case at Justice Anthony Kennedy, who in one of these cases, most of these cases have been brought as equal protection claims. Kennedy offered a novel idea, First Amendment claim. And his essential idea was that by a partisan gerrymander, you were punishing voters for their opinion, punishing them for their views of whether they supported Republicans or Democrats. So it could be positioned as a First Amendment claim in addition to an equal protection claim. We had a great trial. We had wonderful witnesses, 2 very distinguished statisticians who demonstrated in a variety of ways, the right way to do to do a new redistricting, and the wrong way, which is what North Carolina had done. So we get to the Supreme Court, and we're on the cusp of presenting the case to Justice Kennedy and his colleagues when he retired. So now we had Brett Kavanaugh, and the complexion of the court tilted somewhat to the right. We still hoped that John Roberts would go along. At that time, Ruth Bader Ginsburg was still on the court, and it was still possible to imagine a 5-4, I would call it liberal, but to me, it's not a liberal, it's a pro-democracy outcome. And we argued the case. Emmett did the argument. I helped them throughout. We were completely functioning as co-counsel, but one person had to argue. And this was kind of the capstone of Emmett's long and distinguished career, so there's really no doubt that he was the right man to do it. We argued, and to my great regret, John Roberts either didn't get it or, well, I'll just leave it at that. He didn't get it. He thought that the argument against gerrymandering was dependent on proportional representation, which it's not. I won't bother to explain why that's true. And he also wrote in his opinion that it was not justiciable, which is a ridiculous thing to say when state courts around the country are in states that have bans on partisan gerrymandering, adjudicate these cases every day. So we lost. The issue hasn't gone away. And right now, in many ways, our functioning democracy is not functioning as well as it should be.
You're right that our democracy isn't functioning the way it should be. This is certainly an area that we at the Bar Association have focused on over the years and will continue to focus on and continue to highlight areas of reform where improvements can be made to ensure that our democratic institutions function the way they should. You said that you tried often 2 to 3 cases a year, at least as long as I've been here at the firm, tended to be on the higher side, 3 to 4, I think. How'd you balance trial work, which requires a lot of travel all over the country, requires long hours, with your other obligations as a spouse, as a parent?
Well, I think I remember my children's childhood, but my wife sometimes disputes me on this. I was gone for long time periods. In the 90s, I had 4 trials that ran 3 months, 3 months, 6 months, and a year in Chicago. So that was hard, but I made a point of coming home every weekend. We sat 4 days a week, and Friday I'd head for the airport and come to New York, and I'd work, but I'd also take a day off, or at least half a day off, to play with my kids. And then I'd go back to Chicago. But, there's no doubt about it. It's a stressful life, and you've got to make sure that your family is part of it.
Right.
And I've had a very happy marriage and 2 lovely kids as a result.
Let's talk about juries versus judges, right? There's research on whether juries make the right decision relative to judges. When you talk to your European counterparts, sometimes they are shocked that we've got a system that allows for jurors to make significant decisions.
They're always shocked.
So having tried so many cases, before judges and juries, are there any overall conclusions that you have reached at this point in your career? More likely to get it right? More likely to get it wrong?
You get good juries and you get bad judges. So everything's possible. I like juries because I like talking to them. I like interacting. You don't have a conversation with them, but you can look at them and they can look at you, and you can try to make your case understandable. I mean, I always tell witnesses, think that you're talking to an interested but ignorant high school student, just a senior in high school, and that you're telling them, you're explaining whatever it is you're explaining to someone with that knowledge base. And I would say that same is true whether you're in front of a judge or a jury. I've had very good luck with juries. I attribute it to being able to put my finger on what a case turns on, trying to make it understandable from the beginning, opening on that issue, closing on the issue, and keeping the attention of the jury on that issue. I've had good relations with judges as well, and I've had good success there too. But I think there are too many different judges to say judges are better or worse. I mean, there may be some very complicated case that a judge might be better for, but judges, my bottom line on trials is cases are decided on the facts, and you've got to make a story that is fair. It's got to be fair for your client to win. And I've become convinced that if you come up with a story that is fair for your client to win, there will be cases that will support you because the common law supports fair outcomes. And so all you have to do is articulate a fair reason for your client to win and then find the cases that say you're right.
Have you lost cases?
Occasionally.
And how do you recover from losses?
Well, I'll tell you, my worst loss.
And I'll tell you, I'm asking this question having recently coming back from a trial with a loss.
You're going to win. You're going to win on appeal, Mohammed. That is the lesson I'm about to tell you. The lesson is my worst loss was when I was a federal prosecutor. I tried a case, details don't matter. It was a very complicated case before the legendary Judge Weinfeld in the Southern District of New York. It was a case that mattered a lot to me. I thought it was very important. A crooked lawyer and three mobsters. And after we lost, I was depressed for 6 months. I just was, oh my God, how did this happen? What could I have done? In hindsight, there was nothing I could have done. It was a really tough case. I didn't have any witnesses. I had to call hostile witnesses and cross-examine them. But the point is, I was depressed. And I then began my civil career. And I would tell people that I was dreading my first loss in front of a jury because I knew how horrible it would be. And happily, I then went 20 years or so without this adverse event happening, but I eventually lost. And when I lost, I came back to New York with my client and we had dinner together and we plotted out our appeal strategy. And suddenly it wasn't so bad because in criminal case, you lose and you're over. The client, they go free. The bad guys win. But in a civil case, it ain't over. So that's how you deal with a loss in a civil case. You put together an amazing appeal.
Onwards and moving forward. Let's talk about private practice, Greg. So, you've been at Patterson Belknap since
1981, don't exaggerate.
Okay, so since you've been at Patterson Belknap since 1981, and as we heard during the intro, you were the chair of the firm for about 10 years. Are there lessons in law firm leadership that you can impart on us?
You don't get to a position like that, which I hasten to say, was thrust upon me, not something I volunteered for or sought, but you have to be respected and trusted by your colleagues. You have to be fair to everyone. And I came to think of this incorrectly, but emotionally as my firm. And by that, I mean, not that I created it, which I didn't, not that I was the best or only lawyer in the firm, which I wasn't, but that I was personally responsible for everything it did. And if someone screwed up, it embarrassed me. If someone achieved something, it made me proud. And just fairness, trustworthiness. And I think to some extent, I look back on those years with pride because to some extent, Patterson Belknap today is what I wanted it to be. I've always been very committed to pro bono work. And during my tenure, the firm instituted a policy in which every lawyer was required to engage in pro bono activity. And this year we celebrated 20 consecutive years of 100% pro bono participation. And I look at that and I think, yeah, it's pretty good. And so it made me happy. There are lots of frustrations. I mean, there's a old joke that being a chair of a firm or being a managing partner, it's like being a fire hydrant for 50 dogs. So you get a lot of people who are upset for one reason or another and have to deal with them. But I did it with the help of a managing partner. So I don't think I invested more than 5% of my time in chairing the firm and the rest being a practicing lawyer. And the managing partner spent much more time in walking the halls, dealing with flare-ups and the like.
Can you speak about mentorship? Who has mentored you during your career? What did you look for in a mentor? How do you think senior lawyers can can mentor junior lawyers in an effective manner?
Well, I was lucky. I mean, began my career with working for Skelly, Wright, and Thurgood Marshall. I then, in the U.S. Attorney's Office, worked for Bob Fisk, who I continue to think of as the best lawyer I've ever met. And he just dazzled me with his decency, fairness, and brilliance, just absolute brilliance. And then here at Patterson, I worked for the named partner, Harold R. Tyler, former district judge, former deputy attorney general. And all of those experiences exposed me to terrific lawyers achieving at very high levels of professionalism. And by working with them directly, I got to see how they did things and forming relationships with them. I think when you look at mentoring today, everyone is different in how they interact with more junior lawyers. I like to give them responsibility. I like to give them feedback. I think these are kind of the hallmark. These are mentoring 101, right? But not everyone does it. I had a trial a year ago in Florida with a trial team of 10 Patterson Belknap lawyers, and I was the only one who'd ever stood up in court and examined a witness. And I made sure that every single one of the Patterson lawyers stood up and examined a witness. And they were great. I worked with them on their witness outlines and gave them a lot of real-time feedback, both as they were formulating their examinations and then after they'd done them. You got to give feedback in real time, in the moment. It's much more effective than 3 months later. And taking people out to lunch, caring about them, knowing the names of their partners, knowing the names of their children, and just creating a humane workplace.
Let's talk about client relations. You've had some very successful relations with your clients over the years who are, because of your work with them, continue to be clients of our firm. What has characterized your most productive and the most enjoyable client relationships? What advice do you have for junior lawyers?
For junior lawyers, my advice is stay close to your law school classmates because they'll grow up one day and be clients. But more seriously, and then to some extent that happened to me, but friendship has been the heart of my client relationships. Friendship formed in the trenches of adversity, dealing with very difficult cases, client situations where the clients are very worried personally about the case. I mean, there'll be lots of, I would call them petty ante cases that your clients won't care about all that much. But if you're fortunate enough to be involved in a bet the company type case, well, then you're going to spend long hours with your client. And by client, I'm talking really about another lawyer, a lawyer who works for a corporate entity that you're representing. But you'll spend long hours with them worrying, strategizing, and the result of those hours is lifelong friendships. I mean, my closest friends, or some of them today, are people who formed relationships like that with them. They grew up to be general counsels of major companies, and they hired me because they trusted me. They trusted me because of the work we had done together.
So let's talk about those bet the company lawsuits. Obviously, you said that your clients were under a lot of stress because the case involved significant amounts and significant issues. How did you, as a lawyer, as the outside counsel, deal with the stress that comes with dealing with bet the company lawsuits, where whether you win or lose is going to determine whether half of the company or significant number of people are being laid off or not, whether a business line of the company is shut down or not, whether a drug is brought to market under the client's name or not?
I'm not so sure it's dealing with stress per se, but I internalize my clients' problems. My clients' problems are my problems. I have to have a solution to them. And so I've dealt with cases just like those you're referring to. And in each case, basically I devoted endless hours and endless intellectual energy to solving the problem. Right? I mean, I never felt stress in the sense of, oh my goodness, what's going to happen? It was more internal pressure to solve a problem, which is what motivates me.
We talked a little bit about pro bono before and how the firm just celebrated 20th anniversary of having 100% pro bono participation. You've done a lot of work on democracy issues for Common Cause and focused on gerrymandering over the years. How'd you make time to do all of this pro bono work while also juggling so many other things, chairing the firm, being the go-to lawyer for the most important cases that your clients had?
There's, you just make time. I mean, it's a priority. The question is, what is it important for you to do? And I have been blessed throughout my professional career with the assistance of amazing lawyers. I mean, starting with you, Mohammed, but also all of the wonderful lawyers at Patterson Belknap. People like working on these pro bono cases. I mean, it's exciting and important, and they eagerly jump in. And I don't want to, I'll skip naming the many people who've helped me, but I don't do it all myself. I just sort of get things rolling and step back as much as I can.
What are the trends in these water protection cases? Are you concerned with where the courts are heading? Are you concerned about some of the rulings that have come out on the Voting Rights Act in the last 10 years or so?
Yeah, I think it's a tragedy. I mean, honestly, you look back to 1965 when LBJ got the Voting Rights Act passed, and that was transformative. I mean, as before that time, minority voting, particularly in the South, was very low. And then suddenly it shot up. And it shot up because of these laws. And there's been a steadfast assault on them based upon what I believe to be the completely fallacious idea that we don't have to worry about discrimination any longer. And that's just empirically untrue. And so when the Chief Justice says the way to stop discriminating on the basis of race is to stop discriminating on the basis of race, I think that's facile and not a good solution to a very real problem.
Moving to a different subject, Greg, in the last several months, we've gotten you involved with the City Bar Association, and you volunteered on a pro bono basis along with your friend Dave Schultz and a team of lawyers from Patterson Belknap, and Ballard's Farr to work on a major report that our association put out on the need for a mandatory and enforceable code of ethics for Supreme Court justices. How'd you get involved with this project? Why is this an issue that's important to you? And why is it an issue? Why is this issue important for the country?
Well, I got involved because I was having lunch with my friend Dave, and he was very upset about Supreme Court ethics. And for a lot of obvious reasons, there have been, in the last 2 years, I've seen a lot of reports involving Justice Thomas and Justice Alito and boondoggles and large sums of money being bestowed on justices. At the same time, ethical questions about whether they should be sitting on certain cases in the Supreme Court. And so Dave was talking about putting together a letter on this subject that would be signed by lots of lawyers. And I thought, nah, that letters don't do all that much good. How about a thoughtful, serious report that a bar association could issue and that would actually provide some meaningful legal analysis and substantive content that could be used if there ever came a time when either Congress or the court were interested in meaningful reform. And then happily, I knew a very important person at the Bar Association, that would be you, and suggested it. And the next thing I knew, had a project going with a bunch of junior lawyers here who were very enthused to engage on the subject. And I found it very interesting, and also troubling in the sense I hate to be critical of the Supreme Court, which I grew up revering. A couple of years ago, there was a Stanford law professor who did an analysis of the Roberts Court's decisions, and he wrote a law review article in the Harvard Law Review entitled "The Imperial Court." And his point was that the decisions of the Roberts Court were accumulating power in the court and taking away from other branches of government. And I think what our review of their ethics code showed that the same thing is true with respect to ethics, that the court has displayed a unfortunate arrogance in the ethical rules it has drafted for itself. Now, this came about, there was no Supreme Court ethics code until a year ago. And a year ago, in response to what I would say is public uproar over the reported activities, in particular of Justices Alito and Thomas, the court issued its first report, claiming that it always followed the law, but here was their code. And the first thing you saw about the code was it wasn't mandatory. There is a set of rules that apply to district court judges and circuit court judges, and they are all mandatory. A judge shall do A, B, and C. And the U.S. Supreme Court decided shall was too demanding, apparently, for it. And their standard is a justice should do A, B, and C. That's not a very satisfactory first phrase. It makes it a precatory or aspirational code. And it shouldn't be aspirational that a judge recuse himself if he's thought to be biased. That should be mandatory. That was not a mandatory code, and it was not an enforceable code. If a judge misstepped, a district judge or a circuit court judge missteps, they can be subject to sanctions and discipline by the judicial conference. The U.S. Supreme Court can't be sanctioned by anyone. And so there aren't any rules, and it's sadly lawless. So I came away thinking that reform was very desirable and needed.
As I understand it, Greg, and you outlined this in your report, there's apparently already a statute on the books, Section 455 of Title 28 of the U.S. Code, that requires not just lower court federal judges, but also justices of the Supreme Court to abide by certain rules relating to their conduct. Why isn't that particular statute enough? Why do we need Congress to enact a new code of conduct for the court?
Well, it could be enough if the court respected it. And there are two sets of statutes that are mandatory and that apply to the justices. One is the recusal statute, which you were referring to, Section 455, says a justice shall recuse himself if his impartiality may reasonably be questioned. And the Ethics in Government Act, which likewise applies to justices and sets forth mandatory standards for receipt and disclosure of gifts. The Supreme Court has declined to recognize these as binding laws that apply to them. And I find this very disappointing. There are two notable bases for that statement of mine. First, in 2011, Chief Justice Roberts wrote a report to Congress in which he claimed that the Supreme Court complied with ethical standards, but he went out of his way to add the constitutionality of these laws applying to the Supreme Court has never been decided. What was that all about? Why is he making this point that constitutionality is in doubt? That's essentially what he was doing. And more bluntly, Justice Alito said in an interview with the Wall Street Journal a year or two ago, I'm paraphrasing, but in essence, he said, I know this is controversial, but let me say it. Congress has no power to regulate the Supreme Court, period. Well, these are pretty shocking statements, one might think, when there are laws on the books that do regulate the Supreme Court. And as a consequence, we devoted a substantial portion of our report to demonstrating that, in fact, Congress does have the power to regulate the Supreme Court, just as it has the power to set the salaries of justices and law clerks, to provide staffing, to provide a building, provide funding so the lights are on. Congress has tremendous power over the court to set the first day of the court's term as the first Monday in October. And so I found it distressing that Chief Justice Roberts and Justice Alito have suggested that it's in doubt whether Congress can apply normal, decent rules. We're not talking about imposing ridiculous, onerous restrictions on the court. We're talking about receipt of gifts and disclosure of gifts. We're talking about recusing themselves if their impartiality might reasonably be questioned. Congress has set rules like this since the beginning of the Republic. The very first judicial there's a judicial oath Congress set in 1792, and the oath requires justices to swear to deliver impartial justice. That's an ethics rule that's prescribed by Congress. So anyway, we have a lengthy section in our report on that subject. And frankly, because of this, we were concerned that the Supreme Court, if it ever got to hear an appeal, might decide that the Congress overstepped and the Supreme Court's ethics code is unconstitutional. And to prevent against that possibility, we recommended that Congress do what it unequivocally has the right to do, which is assign another court to consider that appeal.
So jurisdiction stripping, in other
That's
words?
the phrase, yeah.
And as I understand it, the DC District Court will have an opportunity under your proposal, or to the Bar Association's proposal now, to take a first pass on the constitutionality of the code, in the congressionally enacted code relating to the Supreme Court, if it is so challenged. And then the final say will be by the DC Court of Appeals.
Right. And this is not a radical idea. This comes straight out of the Constitution, which expressly provides that Congress determines the jurisdiction of the Supreme Court, subject to whatever exceptions it wants to make. And Congress has made exceptions over the years for one reason or another. But we thought that this, of all circumstances, warrants stripping the court of jurisdiction, since there are rules that govern the behavior of the justices. They shouldn't be deciding that. No man should be the judge of his own cause.
Well, those are good words to end on. Greg, really enjoyed our conversation. Thank you for participating in it. And thank you for all that you've done for our Bar Association. And I hope that we'll be able to sign you up for other projects that are important to us and that might intrigue you.
Well, thank you. I enjoyed the discussion and look forward to whatever comes next.
Thank you for listening to this episode of This Lawyer's Life. Opinions expressed are those of the speakers and not necessarily of the City Bar. If you enjoy this podcast, please like and subscribe wherever you listen. Find more City Bar podcasts on Apple, Spotify, YouTube Music, iHeart, or at our website at www.nycbar.org/podcasts. Be sure to check out Building Belonging, a podcast that embraces authentic conversations about DEIB solutions by amplifying the most marginalized voices in the legal industry and exploring spaces others dare not. This podcast was produced and edited by Eli Cohen.